So this, Dorothy is our chair, but I'll just or Dorothy, do you want to do the conflict thing? So you just have to ask if anybody has any conflicts in compliance with the Ethics Commission rule, and if recognizes anybody have any conflicts. If so, you need to say so.
Yes, what Nicole just said.
Does anybody?
Thank you, Nicole, for reminding me of that. If anybody has any conflicts, please make them known now. If there are some that arise later, please let us know at that time. All right.
Good.
Now I can really officially pitch it off, right?
Yes. This has come up with the North Carolina State Bar as a result of the ABA in 2020 issued an amendment to their Rule 1.8E. And Rule 1.8E is the rule that prohibits lawyers from providing financial assistance to litigation clients, whether litigation is pending or contemplated. So our North Carolina rule, as you know, prohibits lawyers from providing financial assistance to any client in connection with pending or contemplated litigation. There are two exceptions in our rule. The lawyer may advance court costs and expenses of litigation, and for indigent clients, lawyers can pay those court costs and expenses of litigation without expecting any kind of repayment. So traditionally, the reason for the prohibition in Rule 1.8E is to avoid or prohibit championing and maintenance. So championing is when the lawyer has a financial stake in the outcome of the client's case. And then maintenance is the fear of frivolous litigation because a lawyer can provide assistance or financial assistance to a client. So those were the general reasons for the rule, and it prohibited any kind of gift to the clients for living expenses. And so that was the main purpose of it. But in 2020, the ABA looked at whether or not an amendment should be made for humanitarian purposes that would allow lawyers to provide small amounts of gifts to clients, meaning things like medicine, maybe transportation, a utility bill, but these were supposed to be for just for small amounts. So their model rule now reads, they've added part 3 of the rule. So our 1.8E looks just like the model rule, except now that the model rule includes part 3 that provides that a lawyer providing representation to an indigent client on a pro bono basis, a lawyer representing an indigent client on a pro bono basis through a nonprofit legal services or public interest organization, so something like legal aid, and a lawyer providing pro bono litigation or representation to clients through a law school clinic or a pro bono program through the law school. And it would allow the lawyer to provide modest gifts to the clients for food, rent, transportation, medicine, and other basic living expenses. The rule, however, does have some limitations. So the rule is very narrow in what it will allow. The lawyer may not promise, assure, or imply the availability of such gifts. So you can't make this promise to the clients that you're going to provide these expenses. And the lawyer cannot offer an inducement to continue the lawyer-client relationship. So you can't put the client in a position where you're telling the client, I'll pay these basic living expenses for you, but only if you don't fire me. The rule also prohibits the lawyer from asking or accepting reimbursement from the client, a relative of the client, or anyone affiliated with the client. So you can't make the gift and then ask for it back. And then the final restriction is that the lawyer may not publicize or advertise the willingness to provide such gifts. So lawyers cannot include on their website or any type of legal advertisement that they offer this kind of gift to clients. The model rule also specifically states that financial assistance under the rule may be provided even if the representation is eligible for fees under a fee shifting statute. So that's a statute that mandates that the losing party in a litigation is going to have to pay the winning party's legal fees. The comments to the model rule basically just like our rules, just give a little bit further explanation as to the reason behind the amendment for humanitarian purposes. I just want to point out a couple of things in the comments, some warnings that they give. For example, if the gift may have consequences to the client, including for receipt of government social services benefits or tax liability, then the lawyer has to consult with the client about that. So that is a warning that if your gift is going to cause the client to lose any social services benefits or create a tax liability, then you have to inform the client of that. And then, of course, you're going to get the client's informed consent to be able to provide the gift, notwithstanding the fact of how it might affect the client. So the client needs to be informed of that so that they can make a decision about whether or not they even want to accept a gift from the lawyer. The next thing that I'd like to point out is that the exception, the humanitarian exception in the model rule does not apply to any lawyer who is going to accept or is expecting to accept a fee. So mainly, like litigation cases that are on a contingency fee basis. So PI, workers' comp, med-mal, those kinds of lawyers are not going to be able to fit into this humanitarian exception. So it doesn't apply to them. It only applies to lawyers who are representing indigent clients on a pro bono basis. So if you're going to accept any kind of fee, then the model rule does not allow for you to give any gifts to the clients. There are a few states, and if you see in the memo that Suzanne prepared at the beginning of the materials that I sent you, there are some states that have humanitarian exceptions. And you can see the list there of different ways that the other states have done it. But for the most part, I think it is still limited to providing pro bono services to indigent clients, although there are a couple of states that allow lawyers to provide humanitarian gifts to litigation clients, whether it's pro bono or not. So I guess the question is, for us to discuss, or for you all to discuss, whether or not North Carolina should follow the ABA and the model rule and amend our rule to create a humanitarian exception. And if so, what should it look like? Should it be limited to just pro bono indigent clients, or can a PI lawyer also offer that service? And that's my report.
All right. Thank you so much for that, Nicole. Anybody have any gut reactions that you want to share? I certainly have some, but I would rather you all start first.
I have tons.
Okay.
I've been thinking about this issue for a long time. I've talked to Brian about it before in the real world context of PI lawyers trying to help their clients not take pennies on the dollar in order to get them through a tough time so that they can get what's fair for their clients. At the end of the day, I feel very strongly that we should at least do what the ABA does and probably do something more broad, with obviously with some parameters. I mean, our purpose is to protect the public, and the only thing this rule really does is protect the public from kind lawyers, which makes absolutely no sense. It is the intellectual background for it is so outdated. The idea that maintenance and chaptery are or what is behind lawyers wanting to give gifts to their clients is insane. That is not what is behind that. There's already litigation funding out there. It's like, instead of taking a free gift from your lawyer, you have to go take a loan shark loan from somebody else in order to get through your litigation. And that harms the public. And if a lawyer has the means and wants to help the client, they ought to be able to help the client. And finally, the idea that it excludes lawyers who'll get a fee, I think, is overstating it too. Lawyers already, I guess it's a gift when a lawyer cuts their fee in order to help their client get more money in the pocket at the end of the day so that they can settle a case. I mean, that's happening every day, especially in the PI world, workers' comp. Well, I don't know about workers' comp, Stuart. I'll let you speak to that. But that happens every day in the world out there. And it's just, it's a long time this is coming. And I wholeheartedly want us to embrace this effort. So that's, like I said, I had a few thoughts.
Thank you for that, Warren. We appreciate your thoughts always. So I heard you, just as a quick recap, you're in favor with us at least going with what the model ABA rule has, with your suggestion or recommendation that we expanded some, at least to some fee receiving attorneys. And you spoke in particular on PI cases and possibly expanded beyond it.
And can I say one more thing here? The whole, in my mind, it is not maintenance and chambtery that's behind this rule. It's fear of plaintiffs' attorneys is really what's behind this rule. That plaintiffs' attorneys are out there, fooling people by giving them, throwing around their largesse, and that they're going to take advantage of this. Gifts are given by attorneys to clients in a lot of different areas of the law already, every day. It's not talked about, and it is out there. It's just not PI attorneys giving it to their PI clients. What we're talking about here is the humanitarian thing here is real. And there are a lot of attorneys that really struggle with this. And there are a lot of attorneys that'll say, I'm never going to do it. That's fine. There's nothing here that compels anybody to do a damn thing. And as long as we don't, allow people to advertise the fact that they're going to, make it rain for their clients with their own money, it's going to be, we can have parameters on it that'll really help people in real need.
Yeah, and if I could just add to what Warren was saying, I do have one or two questions about the material, just some clarification questions for later, but just to kind of piggyback on what Warren said, as a hypothetical, let's just say as a hypothetical, you remember right before Christmas, the week before Christmas, when the vortex or whatever it was called, was the vortex bomb was coming through. Let's just say as a hypothetical, we had a situation, a discrimination case, the federal fair housing discrimination case. So fair housing has a fee sharing piece in it. We can get to paragraph 13 in a little bit, because I do have some questions about paragraph 13. But let's just say hypothetically, we had an elderly disabled vet. The vortex is coming through. He doesn't qualify. His electricity goes out. We have depositions on Monday. He may have to go to Virginia to stay with family members so that he has warmth and electricity. We don't want him to leave because we've got a trial on the calendar for the 23rd of this month. And what Warren said is a scenario that we had to watch, again, hypothetically play out. They don't call them loan sharks, by the way, out there in Rockingham County. You know what they call them? Street loans. And our 77-year-old, 100% disabled veteran, who we have in a discrimination lawsuit, let's just say hypothetically, had to go out in the street and get a street loan so that he could stay in his house and stay warm. to make sure everybody appeared at depositions on. It's pathetic. It's ridiculous. So anyway, I just share that for what it's worth, because what Warren, you're saying hypothetically, I watched play out 2 weeks ago, hypothetically.
Mhm.
I know my boss is on the thing here, and I'm not sure what I'm allowed to say.
Well, I appreciate it. I mean, that was one of the things that I wanted to point out as well, Warren, is that is a huge piece of it, is that, you know, that the exact situation that if people aren't able to get funds in some other way, they are forced to have to go to these loan pieces here. And that I would much rather like to see people being able to get a gift as opposed to having to go that route. Miss Campbell, good to see you.
Good to see you. I have a question about the rule, and I think I know the answer to it about the proposed rule, but Brian or Nicole, I thought perhaps you could help clarify this for me. So if your client is not in active litigation, can you give them a loan? So for example, yeah, I think the answer is no. So the only thing I'll say about that is, so what if someone came to Legal Aid of North Carolina and they were behind on their rent and they had a letter from their landlord that said, if you don't pay your rent, you're going to be evicted. And we had a fund from the city of Raleigh to pay rental assistance and could provide rental assistance to that client to avoid the filing of the summary ejectment action. I think under the proposed rule, we could not give them rent. Is that correct?
Correct, under our current rule or the revised.
Yeah. So I would, ask folks to consider that scenario and maybe have some amendment. And I don't have the specific language on my screen right now, but that says something like, active or anticipated litigation, or if we could perhaps build in some scenario where there's an expectation there could be litigation in the future.
Our current rule says that you can't give money or living expenses to a client that is in either inactive litigation or contemplated litigation. So even if you're trying to handle a matter pre-suit, but if there's still the possibility that litigation is going to be filed, then you can't make that loan to the client. So let me just make sure I'm clear on what you're asking. So you're asking, can you just restate that again, Ashley? I'm sorry.
Yes. So I'd like, for whatever rule that we ultimately consider, to include language that you can make a loan to a client if there's contemplated litigation. Because I think the scenario I just described, where you got a letter that says, if you don't pay your rent, I'm going to sue you, is probably sufficient for contemplated litigation.
Okay.
And you specifically wanted the language to say loan?
No, it doesn't have to be. I think the rest of the language looks fine. I think that it says it has to be a loan. They can't repay you, all that. I think all that's fine.
Okay. That's why I was wondering, because I was thinking that we were looking at that language being active or anticipated litigation, and it still be a humanitarian gift based on the way you described it, with Legal Aid having this fund that they could, because if that were the case, you all wouldn't be expecting to be paid back as in a real loan. Okay.
Correct. Right.
Nicole and Brian, can I ask a question about, so presently, a lawyer can, under what is 1.8A, can a lawyer loan a client money as long as they check all the boxes in 1.8A? And then just
do a business with a client rule?
Yeah, where you can loan, and that seems to be a lot more problematic to me than giving a damn gift. I don't know. I may be wrong, but I think
I'm with you on that, Warren. That's why I asked for that clarification.
Yeah,
I agree, Warren. I think, yes, you can give a loan. Now, 1.8A, the provision that allows you to make that loan conflicts with this notion of not providing financial assistance, because a loan is a form of financial assistance. And so in theory, even a loan would be prohibited under the current version of 1.8E. But it's
And doesn't it, and the loan creates even more of a conflict problem for the attorney and the client, because the attorney expects to get paid back.
Yes. Yeah. If anything, and that's where the there's provisions that are meant to safeguard a client's interest in receiving this loan, but there's still a fair argument that you talk about champerty, right? Like getting an interest in the litigation. If you make a loan to a client who you're representing, then you're creating an indirect interest in the outcome. So I think there's that consistency.
Dorothy.
Yes, sir.
If I could just be heard for just a few minutes.
Absolutely.
Because I run into this problem all the time, and I mentioned it at the ethics meeting. I represent mostly people who are on death row or are facing death row, and they ain't got nothing. They don't have money to make phone calls. They don't have money to talk to their families. Central Prison, the CDPL people want us to donate, and I do donate, gifts every Christmas for the people on death row. It's $100, $125. But every day I go into the jail, and my guys need to talk to their family, or they want a honey bun. And before I leave, I'll put a couple bucks on their account in that machine that charges you $5 if you give them $2. And, it's just, that's the problem. I mean, I don't see any issue with this as long as there's no quid pro quo of any kind, even explicit or understood. You take that plea, or I'm not going to give you any more money on your account. That's wrong. No quid pro quo when it's reasonable, so they can buy a honey bun. I just think, the champerty and maintenance thing, this is ridiculous. This is not what we're talking about. We're talking about giving these guys who got nothing a couple bucks so they can call their family and they can buy a honey bun. And that's the kind of, this language, when I first read into it, I was really stunned because it was so overbroad. And it was addressing maybe different problems. But in my context, in the criminal context, where you're representing indigent people, I'm getting paid for it. I'm not doing it for nothing. But I don't charge it back to the state. I just put $25 on their account as I'm headed out of the jail. So I just don't. This broad prohibition is really just, as George Carlin would say, freaking stupid. I mean, there's nothing wrong with that as long as there's no quid pro quo and it's reasonable. That's my 2 cents.
We didn't hear any of what you just said, by the way.
This is not being recorded.
Right.
Hey, I'm Stuart. I practice in workers' comp and personal injury. So I feel like that's probably why I'm on the subcommittee. But when I read the model rule and the pro bono exception, I think most people would agree with that. I think that should pass easily. And so I think, if we were to put that forward, I don't know that we'd even get a lot of comment on it other than to say that people support it. And so I think it's helpful to know what our legal aid brothers and sisters and other pro bono folks need in order to be able to really effectuate that in the circumstances in which it's necessary. And then, as far as what Warren is saying, so let me go to Mike first. So in Mike's scenario, because he is getting paid, even though it's barely nothing, it's not anything, let's face it, but he's quarter point, so he's getting paid. So I think under this model rule, he wouldn't be able to do the honey bun scenario. Although I think the honey bun scenario is eminently reasonable. And so I think we should consider that and consider if we want to draft something that would allow that. And that's a situation where there's no expectation of repayment and there's no quid pro quo. So, I think that's a different circumstance. Then we get into my people's territory, which is the personal injury, workers' comp. Your client can't pay the light bill, can't pay their car payment, their claim is denied, things like that. And I definitely had that come up. And I definitely have had situations where I've wanted to help. And we've been able to find other forms of assistance for these people in most of those situations. But I think that there's this area is the muddiest to me. And I think it really needs to be, studied if it's something that we want to undertake to try and allow under certain circumstances. I think we need to ask the question of, is it going to be a gift or is it going to be a loan? Because just looking at the summary of what some of these other states have done, it kind of runs the gamut, I think. I mean, some states say that they have very specific terms that have to be met. One of the states says it can't be more than $1,500. It has to be reported to a certain committee. Some states say it has to be necessary to be able to initiate or continue the litigation. And then other states just seem to say it's up to, the judgment of the attorney. If it's necessitous, then it can be allowed. And so I think that really runs the gamut. And, as an attorney, I want to be able to help when I want to be able to help, but I also think that there need to be limitations on that help so that it is limited to what it is intended for, which is living necessities. I always want to help somebody pay their light bill, any of that kind of stuff, but we also need some protection there so that when, the client comes in and needs $5,000 from some amorphous thing, these rules are in place to provide some guidelines. The other thing I'll say, as far as the benevolence of plaintiffs' attorneys, I mean, there are a lot of wonderful plaintiffs' attorneys out there, but there are some advertisers that would abuse
Take
this.
advantage. Yes.
Yeah, they would. And,
Yep.
I wish, that this is not the right committee, but I wish that the state bar would do more when these people violate the rules, but they don't. And so these people keep doing it. And so I say that to say that they may not advertise this, but trust and believe if they're not given very tight parameters on this, that it will be abused, not by everybody, not by the good folk, but by a very small percentage of people that really, have mills and treat this as, what they do with it. Anyway, I think that it's just a spectrum, and on the humanitarian pro bono end, no brainer, and we need to tweak it to make sure they can do what they need to do. But then when we get into the paid representation area, we're going to really need to put some parameters on it if we want to put that out there. And I know NCAJ has new legal affairs counsel, Sam McGee. It would be great to reach out to Sam McGee or the NCAJ CEO, Shannon Luskin, on this, because I just think that obviously it implicates criminal defense attorneys, plaintiffs' attorneys, all kinds of folks.
I just want to throw
100%
one more thing
agree.
out there about, I know, I just thought about this when you were talking about the indigent clients. I just thought about the time that when I was in the public defender's office, and here in Durham, we have, as most public defender offices has, a closet full of clothes for persons who are not able to, don't have the proper clothes to wear to court. And the thought generally is that they would wear it and then bring it back, right? And wear it for court and bring it back. But in some occasions, that may not be what happens. And so that is a situation that would be considered a gift that was given to that person. And I think situations like that should be allowed too. And that, I noticed that it's not, I say basic living expenses, but I think that we should probably consider the different types of gift or different ways the gift could be given, as well as that word modest that's in and I think this is what you were going to, Stuart, to some extent, kind of figuring out what does that really mean, to give us some parameters around how much we could, because modest could be, depending on what kind of lawyer you are, how well you're doing, modest could be something different.
Well, I'll say, Dorothy, just to settle your soul, I consider that an expense of the litigation, how your client looks before the judge. I think if you would have called me, I would have said, I think that's an expense of litigation. So that's for whatever it's worth. But yeah, I want to ask Stuart, you're hitting on something that that's been my focus, the potential harm, that can occur, how it can be abused. And I don't love the idea of writing a rule that's based entirely on how it can be abused, and we curb it for that 3% of lawyers that are going to abuse it when 97% of it will be able to serve their clients well. But at the same time, I could see this being something that, gets a little hairy. So with the ABA model rule, the safeguards they put in there, are those enough to curb this? The safeguards being, now regardless of the indigent pro bono stuff, but that a lawyer can't promise or imply that they're going to be able to give some sort of financial assistance to induce a client to retain the lawyer. They can't seek reimbursement. It has to be a true gift, and they can't advertise their willingness to make this type of gift to any potential client. So it really has to be, I guess, the parameters. I see those safeguards being kind of setting up the situation where lawyer knows in the back of his or her mind they have the ability and they can react when that moment arises. When the client comes up and says, my water's getting shut off tomorrow, can we just settle this case right away because I need money? And you can say, you know what, I can cover your water bill. You would not be well served to settle right now, that sort of thing. But and I guess I have to recognize the reality that word will get around, that somebody's going to be like, oh, if you go to this firm, they can give you money to pay your rent or whatever the modest expense is, however we work that out. But I guess that's kind of my question. Do you think those are enough, or do you think we need something more? Does it come in the form of defining what modest gift is and leaving it to the lawyer's judgment as to what they think is a true humanitarian basic living expense that's been requested? I don't know. What do you think of those parameters?
So I think that if you're talking about a gift, I think those parameters are fine. But some of the states that we're looking at, and I'll say this, it could still be abused, but I don't know what parameters you put on it beyond that. I mean, those seem to be the highlights. You're not getting paid back, you're not advertising it, and then I forget the third. But
you can't induce representation by it.
Yeah, and you're not using it for leverage. I think that's another piece of it. And so but some of these states are looking at loans as opposed to gifts. And I think that's something we need to discuss. I mean, where are we on that? Because I feel like a water bill or a power bill in an exigent circumstance is one thing if you're going to pay that. But when you start getting into paying people's car payments or people's, mortgage or rent, that is a higher expenditure. And I don't think plaintiffs' attorneys or whoever are going to want to pay that ad infinitum. I mean, and it could just not be one request. It could be, multiple months of requests for that. And so are we going to require that to be a gift if it's going to take place? Or are we going to require that to be under a certain amount? Are we going to allow it to be a loan in certain circumstances? Or are we going to say, no, we don't want to allow loans? I mean, I just think that I think that this area of the inquiry just needs tremendous study.
Oh, I agree. I think that's if there's danger, it is in this area. I mean, to the extent that clients can pit attorneys against each other. He said he'd give me a rent. You're saying you can't do it. I don't know. I mean, that's certainly danger out there. I will say, Brian, though, I think the parameters in the ABA rule are kind of ridiculous because they're already limited to you can only do these gifts when you're representing somebody pro bono for no fee. So why are you going to be advertising to the world, hey, come to me for no fee and I'll give you gifts and then represent you? I mean, that's not going to happen. So, I mean, they've written the parameters there for attorneys that are going out there and trying to get clients. I guess that, I mean, it might cover legal aids going out there and trying to get clients, obviously. You know, most pro bono attorneys are not saying, come to me for my pro bono services so I can give you gifts. I mean, that's.
Yeah, no, I agree, Warren. I think it's kind of silly. And I do see those parameters as being more applicable to the lawyers who might potentially be getting a fee. Yeah. And I think personally, I look at those parameters. I know, like I said, word will get around and all that kind of stuff, but I think they're a good starting point. And to Stuart's point, when you were talking about gifts, if it's only gifts, I think those are some good parameters to protect against lawyers. Really, I guess I see it as, kind of the purpose, not trying to bring up champerty and maintenance all the time, but the purpose of those concerns really is that, or part of it is that the client is making a decision on their representation based upon something other than just who can provide the best legal services, who's the best for me. When you add in a financial incentive, then it's, not necessarily this is the best lawyer for me, but this is the lawyer with the deepest pockets that can give me the most gifts, and I hope that they can do a good job. You don't want that in the so I think that's where the safeguards come in. Yeah, I agree. It seems silly to have those associated with the pro bono. It seems more appropriate for folks that are actually trying to.
And clients clients already choose their attorneys based on who can advance expenses of litigation. And there are a lot of attorneys out there who are very good, who might not be in the financial position to advance litigation fees.
So I kind of read that may not publicize or advertise a willingness to provide such gifts to prospective clients safeguard in a different way. I didn't read it to try to get this particular pro bono client, but to be able to advertise in general. I'm the type of firm that offers these types of things, and it could be that you're getting some other clients. It's showing all potential clients that I'm that kind of a lawyer. This is that kind of firm. So even if you're not a you're not a pro bono one, you're paying one. I'm that kind of person. So you should come bring your service to me. That's kind of how I read that on why they probably included it. Because think about it, we're not trying to just advertise. I mean, those folks those kind of attorneys that do that, they're thinking ahead down the road for other clients.
Right. That's a great point.
Isn't it?
I see Ashley has her hand up.
Yeah, I was just going to say, I agree personally that lawyers should be able to make gifts to their clients, regardless of whether they're being paid or not. But for purposes of this rule, I tend to take a relatively conservative approach. And I feel like, and I'm open obviously to the thoughts of others, but I feel like it's a good idea to pass it in this form first and get it through. And then if later you wanted to amend it to include paying lawyers who are being paid, you could do that. But I think that if you try to go ahead and do it all now, it may really cause a lot of problems. And I'm going to go back to that sort of rental assistance example that I gave before, because it's really how this came up. So just by way of background to anyone who may not know, when I was at Campbell Law School before I came to this job at Legal Aid, the city of Raleigh wanted to give Campbell $300,000 for a rental assistance fund, and we asked the state bar about it. So, there are entities out there who really do want to help indigent clients. So these are folks who would have been impacted by COVID and who were losing their housing because of their inability to pay their rent. I would not be in favor of any type of cap on what the amount of the gift is in that scenario, because you could have clients who owe thousands of dollars of rent. But again, you've got a fund that's being used to pay for them. They're indigent clients. They're being served by a legal services organization. I just can't see how that's bad for anyone. And I'll point out, including the landlord who is going to get paid. But if you think about that same scenario where you've got a lawyer who's being paid, who's offering to pay their rent for their client every month, so they can stay in their house and maybe stay in their litigation. There could be other sort of issues or concerns that are different from the scenario that I was just talking about. So I'm not really in favor of a definition of the word modest. I would say it should be, it's sort of like, you know it when you see it based on the circumstances. And then I just worry that if we open this up to lawyers who are paid for their services, that it could sink the whole proposal.
Thank you. Sydney.
I was just gonna say that, could we look at it, and I guess this is a question for Nicole and Brian, as a two-part rule, right? Because I think it's very clear to what everyone's already said. Their pro bono area is a completely different scenario than potentially bad actors in the paid space for attorneys. And so I would suggest, because I don't want to throw the baby out with the bathwater, and I do think there are opportunities, right? So for instance, in juvenile court, you're court appointed, you have a parent who is struggling with regards to setting up a bedroom set for their child in their new apartment. Can you just give them furniture? Can you get somebody else to give them furniture? Can you give them furniture with the intention of a loan that they're going to pay back to you? Or if I just gift them an entire, all their dishes and everything else for their household goods by not working with Green Chair Project, for instance, and just doing it because I have a baby, I don't need the furniture anymore. Like, where do we stop? So I think there needs to be some parameters, because there are a lot of situations in which attorneys, and if you're already doing the court appointed work, most of us are doing that because we love the work, right? We're clearly not doing it for pay. And so if you're in a situation where you find yourself to be in that, I would want to give guidance to attorneys to say, okay, the crib is fine, but not the entire bedroom set and all the furniture and everything else. Because the other issue there is that the attorney is helping the client with regards to a direct outcome in court if the judge has said that you have to establish a safe home for your child, right? So you look like a better attorney because your client's gotten their life together. Therefore, as in turn, the child comes back home, may not be sustainable because maybe you're giving the person assistance in rent that they're not going to be able to do when the child removes themselves. So all of that is long-winded responses to say, I'd like to explore the very clear rule about gift and pro bono, and then a paid attorney, which should include court-appointed attorney, right? It should, like, court-appointed attorneys should not be seen as legal aid attorneys. So I think, or just sheerly a pro bono attorney who's literally just doing it for free. So I don't know if that's an option, but I would suggest that if it is an option, that we explore those two different paths, and if we could have a different rule.
Can I love what you said, Sydney, but I would like to offer that we include the indigent client, court-appointed indigent client in the pro bono scenario. So in the first set, as opposed to them being included with the paid lawyers.
Okay. And I have no preference, I'm perfectly fine with that.
Because I agree with you, and then Mark, what you were saying about the that client when you go to the prison and you want to be able to just give them $5 on there, you know what I mean? But because that's an indigent client, you're court appointed, I see that as kind of falling on the same side over here. Yeah, so that's what I would offer, that little friendly.
I just want to.
I know we're not at motions yet, but
yeah, Sydney's making my brain hurt with that thing. Because that just throws a whole twist in it. Dang, Sydney. But
I always make your brain hurt.
Absolutely right.
But we think about it. We have you got the sincere pro bono, and I wanted to take this step further. I'm sorry, I should have mentioned this before. I would like for it to be the pro bono or indigent client, as opposed to indigent client pro bono. Because the pro bono could include somebody who is indigent or somebody who is just, you want to represent them pro bono. Because for whatever assessment you did as a lawyer, you determined that you want to represent this person pro bono, but they might not necessarily be indigent. If that you know what I'm saying?
Yeah, that's what. So I hear exactly what you're saying. I think the most likely scenario is that it may be somebody, like you say, who doesn't necessarily qualify as indigent, but is right on that cusp. And there are a lot of folks that don't qualify as indigent that are very much in financial need. That's like an area though that I worry about abuse. My gut reaction is do you find somebody who's who's not indigent, nowhere near it, and you are doing some sort of pro bono representation for some side thing, and that's your avenue to now give them something. I want to think about that, because I think you're right. Most likely it's going to be the target client that you're looking for, you're looking to help, but I worry about that potentially being an avenue for abuse. I think that's a good thing to think. I mean, clearly this isn't, we're not resolving this today.
Right.
I think that's another avenue to consider. And I have to say, this is one of those things, it sounds like feels like we're all on the same page, that we know that there is good to be done. And this is an opportunity, lawyers get faced with these opportunities all the time. The rules, we don't want the rules to stand in the way of lawyers being able to do the right thing. But it's finding that balance, right? Of like permitting, allowing, enabling the right thing to be done, while also not creating some mess that ends up, putting either lawyer and client in conflict or just gets abused. Nevertheless, Stuart, I saw you had your hand up.
Mm-hmm.
I agree with what Dorothy said. I think that especially court appointed indigent or indigent clients with court appointed attorneys, I think should be in the same category or near the same category as the pro bono folks. But I would also like to point out that many of my clients are indigent or would be considered indigent, and I'm not a court appointed attorney. So I think we just need to be careful with the language there so that we're specific on the categories of people we're trying to include.
And that's why I was trying to cover that, Stuart, in the indigent or pro bono.
Right.
Yes, sir. Warren.
I don't know how to virtually raise my hand. And I've just been speaking over people. I'm sorry for that. But I echo Ashley's concern that if we try to do too much with this rule, it'll slow down something that needs to happen quickly for a good group of folks right now. And I appreciate that. And I would like to study how we can do more than just the ABA rule, though. And I completely agree that we ought to include the folks who are court appointed, as they're court appointed for a reason, and it's because their clients are indigent and already need help and can't get legal services. So I'd like to include that in our version of this. But getting back to protecting the public, in the PI world, Stuart, that when you have a poor client, the insurance company on the other side that uses that as leverage to get their case settled. Hey, Stuart, I made you an offer. I can get it paid by December, by the end of this month. You better tell your client. But once it's, they can use that too, and that hurts your client. And I'm not saying that obviously you can't fund clients' lifestyle to the end, so that they can, so that you can get them as big a payday as they should get. But on the other hand, with proper parameters, I think you can protect clients so that they have a fair day in court. I don't know. That's just a thought for me. But that takes a lot of study. That does. I think that's because it could be abused, and that is a concern.
Yes, sir.
Thanks. I know we're getting close to the time here, and I know how adamant Brian is about sticking to time, but Nicole or Brian, if y'all wouldn't mind clarifying paragraph 13 before we get off here. The first sentence, I believe, is relatively clear. the second sentence of paragraph 13, I wasn't sure I completely understood the difference here, and I am trying to open mine up.
Are you talking about the comment?
Talking about the comment to the
Yes, I
model?
am. I apologize. Paragraph 13 of the official comments, or the proposed official comments, that begins, financial assistance, including modest gifts pursuant to paragraph E3, may be provided even if the representation is eligible for fees under a fee shifting statute, period, full stop. Totally get that. And that seems like it would be fine and applicable to the fee shifting statutes such as are built into the Federal Fair Housing Act. Great. Second sentence though. However, paragraph E3 does not permit lawyers to provide assistance in other contemplated or pending litigation in which a lawyer may eventually recover a fee, such as contingent fee, personal injury. Okay, and I know we're going to talk about maybe that as a separate piece, but putting a pin in that for a second, that or cases in which fees may be available under a contractual fee shifting provision, even if the lawyer does not eventually receive a fee. So for example, in our retainer agreement, our standard retainer agreement, for cases such as the Federal Fair Housing case, we have it built in that it is understood by the client, so they understand what we're doing. You know, we have to front money for depositions, that's explained. If there's the potentiality of recovering attorney's fees, that's explained. We try and cover our bases here. But as I read the second sentence, I wasn't sure if that then would capture our situation where, because there's a fee shifting arrangement statutorily provided by the Federal Fair Housing Act, if that would negate our ability in the scenario, the hypothetical that I gave earlier. And again, Brian and Nicole, I may just be misreading this or.
So let me try to tackle this. So
Okay,
in your fair housing, there is a statute for fee shifting, correct?
Right.
So which
Yes.
means that the loser has to pay the winner's attorney's fees, right? Is that what that means?
Yeah, as far as I understand it. Now, I talked about this with some of our fair housing experts, and I was under the impression that it was simply like Chapter 75, where it allowed for attorney's fees. But I was informed that it included a fee shifting provision.
So under the model rule, if there is a statute that allows for fee shifting, then you can
Right.
still provide the gift. Under
Right.
his comments, the contractual, the best example that I can think of is like in a domestic situation where a domestic lawyer tells a client, you don't have, we're going to try to get my fees paid by the other side. So
Okay.
if the other side pays my fee, then you don't owe me a fee.
Gotcha.
So I think, which is contractual, that is not allowed by statute necessarily, but, or not allowed by statute, but where the lawyer and the client are agreeing by contract that the fee will be shifted to somebody other than the client.
Okay. And that would then not.
I think
anything
that's what
to do
that
with-
means. I mean,
Okay. And no, and I
Brian, do you have
appreciate
any
that,
insight
Nicole. I
on that?
appreciate that.
No, I think I read it that way too, Nicole.
yeah, that's
Okay.
why I read it.
Okay. So no matter what we have in our retainer, in other words, our contractual relationship with the client.
Right, because there's a statute that allows for it. But if there
Right.
was no statute on point, then you cannot contract with
Gotcha.
your client to shift the fee and try to, fit under this humanitarian exception.
Gotcha. Okay. Excellent. Thank you.
And that's one of those things, Jack, I have to say, this is an opportunity. If we go this route, it sounds like we're going to draft something, we can improve on that language. There are a lot of opportunities where we see the ABA model rules, advertising rules in particular. I can't recall if anybody on this call was on the advertising committee. There we go, Warren. For 2 years, we looked at every single word that the ABA wrote. in their model rules on advertising when they did the overhaul. And we changed a lot. We kept some, but made it our own. And I think that might be, I think it could be better draft, put it that way.
So we're at the hour mark, look like a minute over. And I don't want to keep folks too long, but so I think it sounds like you said, Brian, we're at at least some consensus that if you all do you think we're at a good place for you and Nicole to work together on a draft that includes the indigent and pro bono, kind of looking somewhat at that word modest, giving us some feedback on that. And then maybe having a carve out separate as what Sydney indicated is for the paid folks. And we can
I think so. And I think once we put it down in writing, you know, this first part is probably going to look similar to what we see in the model rule, but then it's going to be tweaked, or at least similar in terms of structure. And then the other side of it might be kind of an E4, so to speak. I don't know. I had to get off the call earlier for something else. I didn't know if anybody tackled the whole notion of, you know, transactional lawyers don't have to even worry about this. This is only limited to litigation. Do we think that's appropriate? But maybe that's another can of worms to open for another day.
Exactly.
Oh, that's big.
This only applies to litigation.
Because of fear of
transactional
champery
lawyer,
and maintenance. It doesn't have, you know, I can be a transactional lawyer. I can advertise from here till the cows come home that I'll give you gifts. Come hire me. I don't care how rich you are, which frankly, big corporations and the lawyers who represent big corporations, they do that.
Like
I
I
will
should
say,
have been
Warren,
there
that
to
go to the
few times I've
we
been
got box
asked
seats
about
for the
that.
Canes playoff game. Come on, boy. That's
The
awesome.
few times that I've been asked about that over the years, I've told lawyers, like, do not do that.
Don't do it. If they're
Don't
not
do it.
litigation, they can do it.
Somebody's gonna file a grievance against you. So even if it's allowed, but like that's just, I tell them no. So I don't get asked about that very often though.
Yeah, no, you don't.
Anyway, we're in a good starting spot though, Judge. So I think we can get back to you all. Certainly, you know, we don't need to have anything. I don't think there's any reason to think that we'll have anything for the January meeting, but it's a good first meeting, and we'll kind of move from there.
We wouldn't do that to you all.
Thank you.
You already got a lot on your plate getting ready for the normal stuff for January. Okay. So I think we're at a good place unless anybody, as they say, all hearts and minds are clear. At least for now, right? Okay. So we'll listen out from you all, or everybody should listen out or look out for an email for the next scheduled meeting for us to try to plan that, with the thought that Nicole and Brian, you all will be working on that for us and have it for us the next time.
Great.
All right. Thank you, everybody.
Thank
And
you.
Happy New Year. I should have said
Thanks,
that.
everybody.
I apologize, y'all, for not saying.
Yeah.
I'll send you
Thank
that
you.
stuff, Dorothy.
Thank you, Warren.
Sorry about that. I'm
You
getting
get
a little out of
my
brain.
full complete smile and not the side.
There you go.